Before I start, I want to say that I'm not affiliated with 99% Melbourne in any way apart from following them on Facebook. They made a post a few days ago for which they have my gratitude because I think it's important for us all to be informed, and I'm just going to start by telling you about that post. And what that says is Victorian Parliament in Australia passed a bill making protest illegal at 1 a.m. this morning. Police can now order you to leave a political protest and then arrest you. In case you were wondering if protest worked, the Liberals think it does. If you're wondering what a fascist police state looks like, stay silent. We will all see. Now, that sounds fairly extreme. That image is fairly graphic. But one of the things with living in a democracy is it is up to us to make our best effort to be informed. So keeping that in mind, I've gone to Google and I've done a search on Victoria Parliament bills passed. Now I'm taking you through this process just simply so that you can see how easy it is. It's something that anyone can do. Now, so we have a list of bills passed this week, and down the bottom we've got passed in Parliament. We'll now go to the Governor for Royal Assent. Now, up until a couple of days ago, I knew absolutely nothing at all about this process. I've learned everything I've learnt off the internet. So we've got the Summary Offences and Sentencing Amendment Bill 2013, and we open that up and we get a document that gives us a little bit of an explanation of what's going on. It tells us that this bill changes two areas of the law. It amends the Summary Offences Act 1966 to provide for additional circumstances in which police members and protective services officers may direct a person to move on from a public place, and clarifies the operation of those powers. This bill also creates a new move on related exclusion order scheme within the Summary Offences Act. So this is the bill that we're interested in. And my attention's drawn to the reference to protective services officers. I thought PSOs were people who dealt with people on public transport, but Google search tells me they are so much more than that. So we see the image here, Protective Services Officer with the Victoria Police badge. Then we have some commentary here, Victoria Police offers a challenging and rewarding career serving the Victorian community. If successful in your application as an employee of Victoria Police, you will be entrusted with considerable authority and responsibility. Their inclusion in this, the inclusion of PSOs in this legislation would suggest that they are indeed entrusted with considerable authority and responsibility. So let's have a look at what they need to do to be entrusted with that authority. Protective Services officers will receive a 12-week comprehensive paid training schedule at the Victoria Police Academy, and after completion of the 12-week training course will gain the knowledge, skills and confidence while completing an on-the-job training program for a further 3 months with the police members. So it's a total of 6 months training. My attention is also drawn to this image here, which shows a PSO on the firing range. I watched this video, and indeed it appears that Protective Services officers are licensed to carry guns after their 6 months of training while they are dealing with members of the public. So that is a bit of a concern. I think 6 months training isn't enough for people to learn how to deal with people in explosive situations, to handle a gun, and also to learn the various aspects of law that they're required to learn. I did some extra Googling, and it would seem that my concerns are not unfounded. We see here in the Herald Sun News, Protective Services officers are 4 times more likely to be attacked on the job than police, and that's hardly surprising given that there are so many things that they need to know how to deal with, but they only have 6 months training before being sent out to deal with the public while handling a gun. And here in the Australian, we have another article about a PSO having his gun stolen. That's potentially something else that may have been avoided had he had further training. Again, 6 months really isn't enough. And we have another one here: police forced to withdraw hundreds of PSO issued fines after law bungle. Police have blamed a misrepresentation of the law following revelations that PSOs working at train stations have been issuing fines without legal authority to do so. Again, hardly surprising, they've only had 6 months training. Scrolling down, the next point of interest appears to be this clause 2 on page 2 that says the bill will come into operation on a day or days to be proclaimed with a default commencement date of the 1st of September 2014. So, not being familiar with the process, I did some research to try and understand what that would mean. Now, here on the Victorian Parliament Government website, we have the summary of stages in each house. So bills only become law when the Legislative Assembly and the Legislative Council pass them and the Governor gives them royal assent. So we're still waiting for royal assent, is my understanding. If we scroll down, royal assent is when the Governor on behalf of the Queen approves the bill which both houses have passed. When the bill is given royal assent, it becomes an act, or it becomes law. The date the act commences depends on the details of the act itself. The Governor may need to proclaim that certain sections come into force for them to commence. Assent and proclamation dates are published in the Victorian Government Gazette. So from what I can understand, this legislation isn't law yet unless they proclaim a date and publish it in the Government Gazette. It will not come into effect until the 1st of September 2014. So chances are it won't interfere with our March in March coming up in the next week. But to be certain, we probably need to keep an eye on the Government Gazette. So I've just read ahead and realised that I should have actually had a look at Clause 1, which sets out the main purposes of the bill, which are to amend the Summary Offences Act 1966 in relation to directions to move on and to provide for the making of exclusion orders from public places, and to amend the Sentencing Act 1991. Okay, I'm not going to be looking at the Sentencing Act, just simply because that's about alcohol exclusions, and what we're interested in is the move on orders. So I'll just take you to have a look at Section 6 of the Summary Offences Act, which is one of the sections that's being changed, just so that you can see what it looks like before the change goes through. So the date is the 12th of March 2014. And what the Act says today is that a member of the police force or a protective services officer on duty at a designated place may give a direction to a person or persons in a public place to leave the public place or part of the public place if the member or officer suspects on reasonable grounds that the person or persons are breaching or likely to breach the peace, or they're going to endanger someone's safety, or they're going to cause injury to a person, damage to a property, or some kind of public safety risk. The direction can be given orally. The direction under this section may direct the person to not come back for 24 hours, and a person cannot contravene this direction without reasonable cause. So, and there's a penalty that applies for doing that. Part 5 of this section says that the section does not apply in relation to a person who, whether in the company of others other persons or not, is picketing a place of employment or demonstrating or protesting about a particular issue, or speaking, bearing, or otherwise identifying with a banner, placard, or sign, or otherwise behaving in a way that is apparently intended to publicise the person's view about a particular issue. So basically, the way it stands at the moment is a member of the police force or a protective services officer can ask you to move on from a location, and you're not allowed to come back for 24 hours if they tell you to not come back for 24 hours unless one of these applies. So if you're picketing or protesting, at the moment they can't actually tell you to move on according to this section. Looking ahead, the explanatory memorandum does get rather unwieldy, so this is a good time to swap and have a look at the introduction print. Now, the difference between the introduction print and the explanatory memorandum is that rather than explaining the changes, the introduction print actually documents and details them. To give you an example of what I mean by that, if we scroll down, it explains very clearly exactly what the amendments are to be made. So for instance, here it says directions to move on in section 61C of the Summary Offences Act for safety, substitute safety or. So what that means is we go back to the original Act and 61C where it says safety, that there will be substituted with safety or. And then when we go back, we see again after section 61C of the Summary Offences Act, insert the following. So that's the exact text that needs to be inserted afterwards. So if we go back to the original Act, we can see we've got an A, B, C clause, and after we make these changes there'll be a D, E, F, G, H clause as well. So what I've done, just to make this a little easier, is I've put together a document that shows what the new version will look like. So here we've got our original version, which we can see fits fairly neatly on a page, is quite easy to understand, with the amendments as per this document, which isn't showing very well at the moment. This section is transformed from this to all of this, so it becomes quite a long and unwieldy document, but we'll go through the relevant bits piece by piece. Clause 1 explains the reasons why a member of the police force or a protective services officer can ask a member of the public to leave a public place. These first three reasons exist in the legislation as it is today, and they include that the person is breaching or likely to breach the peace, they're endangering or likely to endanger the safety of another person, or their behaviour is likely to cause injury to a person, damage to property, or otherwise a risk to public safety. These are the 5 new circumstances that have been added where a member of the police force or a protective services officer can ask the member of the public to move on. And they include that the person's committed an offence within the last 12 hours, that the conduct is causing a reasonable apprehension of violence in another person, that they're likely to cause an undue obstruction to another person or traffic, that they're there for the purpose of supplying or receiving drugs, that they're impeding or attempting to impede someone from lawfully or entering or leaving a premises. Clause 1A is the new clause. Just a bit of clarification. Clause number 2 is being amended to refer to groups as well as individuals, so it just basically says that a direction under this section may be given orally and may apply to an individual person or a group of persons. Clause number 3 is unchanged. Clause number 4 is unchanged. Now, the big changes come with clause number 5 and the introduction of clause number 6. Okay, subsection 5 is where we see the changes in relation to picketing, demonstrating, protesting. In the current version of the legislation, the section doesn't apply to people who are picketing, demonstrating or protesting, but the new version, all of these factors will apply to people who are picketing or demonstrating except for breaching the peace or being an obstruction to traffic or people. So that's basically the end of the changes to the Summary Offences Act 1966 Section 6. As you can see, it's taken about a page and expanded it to about a page and a half. It's probably actually about 2 pages with the same kind of spacing. The rest is all new, and that's about 7 pages of new legislation. Section 6A is a completely new section. It relates to arrest powers. Previously, if you were asked to move on by a police officer or a PSO and you didn't move on, you could be fined 5 penalty units, which is a monetary amount. When this becomes law, police and PSOs will be able to physically arrest you. Okay, subsection 2. That indicates that a PSO is required to hand you over to the custody of a police officer as soon as possible. Subsection 3 indicates that the police officer can't hold you in custody for any longer than what's necessary, and the only reasons they can hold you in custody is if they need to ensure your attendance before a court, or to preserve public order, to prevent the continuation or repetition of the offence, or for the safety or welfare of members of the public, or for your own safety. And subsection 4 indicates that once it's deemed that you no longer need to be kept in detention for any of these reasons, then they are obliged to release you. In summary, Section 6A is a completely new section. PSOs and police officers will be able to arrest you if they ask you to move on and you do not comply in accordance with the Summary Offences Act 1966 Section 6. Another new section, 6B, the requirement to give name and address. A member of the police force, if they're intending to give you a direction to move on, they can request your name and address, but they do have to let you know that it is their intention to give you a direction to move on, and you are not allowed to refuse to provide your name and address, and you're not allowed to state a false name or address. If you do, there's a penalty that applies of 5 penalty units. What's interesting to note about this is it only refers to the police force. There's no mention of PSOs in this clause, so I would assume based on that under this clause, PSOs aren't allowed to ask you for your name and address in relation to a direction to move on. And subsection 4 indicates that if you're asked for your name and address in relation to a direction to move on, that you are entitled to request the police officer's name, rank and place of duty. Subsection 5 says that the police officer cannot refuse or fail to comply with your request, including providing the details in writing if you specifically ask for the details in writing, and they're not allowed to provide you with false details, and they're liable for a penalty if they do. Now, this is important because at the March in March this weekend, there may be some confusion, and it is possible that a police officer may ask you for your name and address in relation to a direction to move on, which from my understanding they're not yet allowed to do, in which case I would certainly ask for their details in writing, and I would have my camera handy or my mobile phone handy, and I would take a picture of the officer. Subsection 6 indicates that if a police officer asks you for your name and address and they don't believe you, that you do need to provide evidence of what your name and address is. And subsection 7 indicates that if you do not comply, you can be penalised 5 penalty units. Now this one concerns me a little, just from the perspective that I don't tend to carry my driver's license with me everywhere I go. I've never been required to carry my driver's license when I catch a train in the past, so I'm not sure how I would prove my ID, and this essentially to me says that I can be penalised for not producing my ID. Subsection 8, that just indicates that it's not an offence for a person to fail to comply with the request made for your name and address if the officer doesn't advise you that it's an offence to not comply. So if they just say, I want your name and address, and you don't give it to them, and they don't tell you it's an offence to not give it to them, then it's not an offence. Division 1B is a totally new section. It's about exclusion orders. An exclusion order is basically an order made by the Magistrates Court that prohibits a person from entering a specific public place for 12 months or up to 12 months. 6C is the definition, 6D is the process that the police officer goes through, 6E gives some guidelines for how the application is determined. Now it explains here that on an application under section 6D, the court may make an exclusion order in respect of a person if the court is satisfied on the balance of probabilities that in respect of the same public place or part of the public place, the person has been given a direction to move on 3 or more times within a period of 6 months or 5 or more times within a period of 12 months. So basically, if you've been asked to move on 3 or more times, or if they suspect that there's a pretty good chance that you've been asked to move on 3 or more times within a period of 6 months or 5 or more times within a period of 12 months, you could be excluded from entering that area again for a period of up to 12 months. So there's about another page of detail that relates to section 6C, the determination of application, and it's basically around the decision making process and about the information that the exclusion order must contain. What I think is the most significant part of this is this line here, if the court is satisfied on the balance of probabilities, because to me that throws innocent until proven guilty out of the window. I also think the legislation's particularly harsh because the exclusion order can apply if you have been given a direction to move on 3 or more times within a period of 6 months or 5 or more times within a period of 12 months. So that's not as a result of you refusing to move on, that is a result of you simply being requested to move on. Section 6F, that basically explains when the exclusion order takes effect. If you're at the court when the order is made, then it takes effect from that time. Or alternatively, if you're not at the court and a copy of the order is served on you, it takes effect 7 days after. Section 6G, that's the section we're all interested in, and basically what that says is if you're under an exclusion order and you violate that exclusion order, then you're liable for 2 years imprisonment. Okay, so I think that pretty much covers the bits that we're mostly interested in. There is more to the legislation. There's section 6H, variation of the exclusion order, and 6I, revocation, and 6J, the Chief Commissioner's reporting responsibilities. You can always look those up on the internet if you're interested in knowing more about that. So I want to draw your attention to a submission regarding this new legislation from Justice Connect Homeless Law. It's a great document relating to how this legislation will impact on homeless people. If you get a chance to have a look at it, do. But since we're particularly looking at protest, I just want to draw your attention to this section here. And what that says is, the bill unjustifiably and unreasonably limits rights. The bill proposes significant limitations on the right to freedom of movement protected in the Charter of Human Rights and Responsibilities Act 2006, and may also limit rights to freedom of peaceful assembly, freedom of association and freedom of expression. While rights can of course be permissibly limited, it is not clear that these limitations are reasonable or demonstrably justified. The bill is identified as intending to better protect the community from lawless behaviour in our streets. Concerningly, the bill creates powers for police and PSOs to direct people to move on and to arrest people for contravening the move on direction when there is no suggestion of jeopardised public safety. For example, where a person has littered in the area, possessed an open container of liquor, or even jaywalked. The limitations on rights are serious for all members of the community, but particularly for people experiencing homelessness. I have no doubt that this is really bad legislation that is a significant threat to our way of life today. One of my concerns is the role of PSOs, and we have been accustomed to PSOs being on the railways, and so for most people they'll be thinking, well, in relation to this legislation, the PSOs will just be operating at the railway stations. Well, I've been trying to find a definition of designated place, because that's what it says in this section: protective services officer on duty at a designated place. So we go to the Summary Offences Act, the definitions, and it defines a designated place as having the same meaning as it had in section 118D of the Police Regulation Act in 1958. So I went to the Police Regulation Act, and all it tells me is a designated place means a place prescribed by the regulations. I don't know how other people interpret that. For me, that's pretty meaningless. Maybe there's someone out there who knows a little bit more about law and they can expand on that. I was able to find in the same regulation a section on the appointment of protective services officers, and what that says is the Chief Commissioner may, in accordance with the regulations, appoint and promote so many protective services officers as the Governor and Council thinks necessary for the purposes of providing services for the protection of persons holding certain official or public offices, the general public in certain places of public importance. So it appears the scope of PSOs is a lot broader than just railway stations. It seems we currently have a massive demand for protective services officers. I did a job search on Seek for protective services officers in Victoria, and I found a whole heap of ads. It looks like they advertise every week, and they advertise under a number of categories. They advertise in government and defence, manufacturing, transport and logistics, that's an interesting one. They advertise in trades and services, again that's an interesting category to advertise for protective services officers. Call centre and customer service, retail and consumer products. It seems they're advertising in a whole heap of categories very consistently for protective services officers. And don't forget, you have a starting salary from $53,641 the day you commence training. So it's interesting at a time when we don't have funds for education, we don't have money to pay pensions, we find that we need to put single mums under incredible hardship, that we have this unlimited bucket of money for protective services officers with salaries starting from $53,641 a year, and then they get all these incredible conditions: 7 weeks of rec leave per year with an additional 10 days accrued time off, 15 days of sick leave per year, a range of other generous leave entitlements including maternity, paternity and study leave, and they get long service leave after just 7.5 years of service. So in summary, I think this is really bad and dangerous legislation. I think that danger is compounded by the fact that it's potentially going to be enforced by people who have had only 6 months training and are carrying guns, and they're going to be dealing with members of the public in explosive situations. Very, very bad. Now, finally, I just want to reiterate that I don't believe that this legislation will be in place for the March in March this weekend. And it's important for us to understand that, because a lot of people are seeing the March in March protest as a test for what this legislation is going to be like. So we need to understand whether it's actually in operation or not. I don't believe it's law yet. I don't believe it'll be law probably until September, but we need to keep our eyes open. I'll be updating at the Free People Agreement page on Facebook, or alternatively the Free People Agreement page at chatira.wordpress.com.